Good morning and welcome to the Law Office of Kyle Watkins. What should your client do after shooting in self-defense? After the shooting has stopped and the threat is gone, the first thing, put the gun back where you got it. If it was in a holster, put it back in the holster. If it was in the center console, put it back in the center console. Don't unload it or mess with it, just put it away. Next, call 911. That's right, you're going to make a statement that can and will be used against you. You are going to win the race to the police by being the first 911 caller. You must know that often the first call 911 puts the wheels in motion in favor of the first caller, the reportee, being labeled a crime victim and the other guy being labeled offender. You're going to give a very brief, limited statement to the 911 operator to let the police know only as much as they need to know that this is a self-defense case. My name is Kyle Watkins. I'm at 1234 Main Street. I have been attacked by, fill in the blank if you know their name. If not, describe the person. A white male, approximately 6 feet tall, 200 pounds, wearing a white shirt and blue jeans. There is someone here that has been shot. Please send police and emergency medical services. And then I'm going to hang up that phone. The 911 dispatcher, it's her job to keep you on the phone, on the line, until the police arrive. And she's going to have around 40 questions for you. Number one, you've already said all you're going to say and are not making any more statements until your lawyer is present. The more you say now, the more you lock yourself into a box. And if I'm the prosecutor, you can bet I'm going to use every word you say against you. Number two, you have more phone calls that you need to make. And now you have about 2 minutes until officers begin to arrive. The next call, the object of this call is to get a lawyer to you as soon as possible. You're going to start calling the people that are going to come through for you. Whoever that is, your spouse, your brother, your cousin, your close friend. The call that you make, the first one, if they answer, you tell them, I had to shoot someone in self-defense just now, and I need you to find me the best criminal defense attorney that you can and get him or her to meet me at 1234 Main Street in Belton, Texas. If your first call is not answered, leave a message saying the same thing. Then move on to your second call. And if they don't answer, leave a message and move on to your third call. And keep doing that until you get someone on the line or the police get there. Once the police arrive, they are going to pull their guns. They are going to order you to the ground. You move slowly and deliberately, just as they instruct. The officers are going to ask you what happened. You give them just enough to let them know this is a self-defense case. But we are not going into the facts of the case. Very similar to what you said to the 911 dispatcher. My name is Kyle Watkins. I was attacked by so-and-so with a such and such a weapon. I last saw the weapon over there. I want to make a statement, but I want my lawyer present when I do so. And then you stop talking. You are not answering questions. After a few minutes, officer number 2 will walk up and ask what happened. And you tell her, I'm going to answer questions, but I want my attorney here when I do. If you've been injured and need medical attention, the paramedics and the nurses are all going to document what you tell them. They are potential witnesses against you in your trial. Tell them only what they need to know to assist you. I was stabbed here, my heart hurts, my side hurts, but for heaven's sake, please do not tell them about the circumstances. We were arguing about my ex-girlfriend. No. Tell them only what they need to know. You will be detained. Maybe not arrested, but at least detained. You will get handcuffed, and they will take you to the police station. Plan on it. No small talk. Do not let your guard down. If your lawyer is not there yet, they may read you your Miranda rights and ask if you want to make a statement. You say no. You can tell them your lawyer is on the way, but no statements until your lawyer is there. Now, lawyer, when you get there, you need to ask to speak to your client in a place with no recording equipment. Usually they have a conference room. You are going to get the story from the client, and then you're going to have to make a call. Is this self-defense or not? Lots of times, the facts are in the gray area, what's sometimes called imperfect self-defense, and you have to decide right then. If you wait days or weeks or months to make a statement, the DA will say, oh, well, he's had time to fabricate. And that is just not the case when you make a statement the same day. There will be curveballs. It may be self-defense, but the client threw the gun in the lake. You have to assess this information, synthesize it, and make the call. Making a statement right away can be the absolute best thing that you can do, and it can be the absolute worst thing you do. This is where experience comes in. If you get in there and you don't know, you'd better get a mentor attorney on the line ASAP to figure this thing out. Now, lawyer, let's say you do decide to make a statement. You are going to briefly prep your client and tell him, number one, keep your answers short, 1 to 2 sentences. Number two, you tell your client, one of the things I'm not going to let you do is tell the story 3 times. Each time you tell it, there will be little inconsistencies, and a clever prosecutor can add those up, stitch them together, call you a liar, and get you convicted on those inconsistencies. We are going to tell the story 1 time. Then we get up, we go in there, and we make the statement. Before we start, you, lawyer, put the detectives on notice, something to the effect of, I'm going to have him make a statement and answer questions, but he's not going to be telling it over and over again and answering the same questions over and over again. The detectives will not immediately complain about that, they never do, but then during the interview they will inevitably ask the same questions a second time, a third time, and that's when you put your hand up over your client like this and say to the detective, he's already answered that. And every time they do it, you shut their questions down until they run out of questions. The way I think of it is like you're in a trial. Your client is the witness, the detective is the questioning attorney, and you're the judge. You are in control of the room, and you're damn sure in control of the questions. You're polite and you're professional, but you are not having any of this asked and answered repetitious questioning. And it is a heck of a lot easier than when you are in a real trial where you have to make a record. And here you just chime in and say, nope, he's already answered that. What's the next question? The last thing, when you first sit down, the detectives will say, tell us the story. You put your hand in front of your client like this and say to the detectives, that is not a question. We are here to answer questions. Please ask a question. You do not want your client going off into a narrative for 1 or Lord help us 2 minutes. Think of it like a trial. No narrative. The form is question and answer. They ask a question and your client gives a 1 to 2 sentence answer. If this video was helpful to you, please hit the thumbs up button. It helps to push this information out to more people that may benefit from it. And if you are interested in keeping current on criminal law and procedure issues, please hit the subscribe button and get notified when new content is released. See you next time.